Court, all rise, please. Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. You are there, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Rubin and Blake will be the panel for all of the cases today. Most of you have been here, or all of you have been here before. You don't understand the general rules. We've read everything. Each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. With that, we'll call the first case is 22P 134, GODERE versus City of Chicopee. Mr. Gambaccini, how'd I do? Was that close?
Very close, Your Honor.
Okay.
Good morning, Your Honors, and may it please the Court. Andy Gambaccini for Jeffrey GODERE. As stated in the briefing, this is somewhat of an atypical challenge to a Civil Service Commission decision. While there might be some disagreement with some of the factual findings of the Commission, for purposes of this appeal as before the Superior Court, we are not challenging any of the Commission's factual determinations. And in fact, with respect to its legal analysis, we find ourselves in agreement with almost all of it. The challenge in this appeal, Your Honors, is that if the Commission's factual determinations are credited as reasonably supported in the record, and if its legal analysis is for the most part sound and accurate, those factual determinations and that legal analysis can lead the Commission properly only to one result, which is not the result it reached here. Our challenge, Your Honors, is to the bottom line result of the Commission. The Commission's own factual findings and its articulated rationale for why the decision of the City of Chicopee to terminate Jeffrey GODERE as a police sergeant, instead of leading to the imposition of what remains serious discipline, a demotion in rank, should have led to the allowance of Jeffrey GODERE's appeal in full.
But weren't there two different actions? Don't we have the problem being both the use of the cell phone and secondarily the lying?
So, Your Honor, just to backtrack as the chronology plays out, in 2012, when the internal affairs investigation was completed by the then deputy chief, there was a recommendation from the deputy chief to the then chief, John Ferraro, that Mr. GODERE and another officer be charged with untruthfulness. The chief decided that he was not going to pursue that charge with respect to any officer. A decision not
And then he got a written warning.
Correct.
That's when the Brady memo happens.
Correct.
In 2013. And then in 2015, he's suspended and demoted for what happened in February of 2015, not what happened with the photographs.
Correct. The 2015 discipline was in no way related to the 2012 discipline. It's an intervening event that does not tie substantively to those events.
And then he's terminated, at least initially, in 18 for what happened in 2012, that being untruthful in an internal affairs investigation.
From 2011 and 2012, yes, Your Honor. And our point is that the decision of then Chief John Ferraro not to charge is a disciplinary determination that should be entitled to the same finality and respect that a disciplinary decision to charge or to charge on some issues and not others. But even if...
How is the determination not to charge, how is it even documented? Is that a thing? Does he get a letter or something saying, we have concluded that no discipline will be imposed, or just nothing happens and it just sits there?
What we have, so there's nothing in writing. We have the Deputy Chief's internal affairs investigation. What we have in our record is the testimony from the Civil Service Commission hearing in which then Chief William Jebb indicated that there was a meeting between he and Chief Ferraro where he made the recommendation and Chief Ferraro decided not to proceed on that basis.
It's not quite like an acquittal, right? I mean, there's no judgment, there's no action taken. And maybe there's a statute, but there is no statute of limitations either, so.
There is no strict statutory provision that calls for a statute of limitations. Where we see a like principle in the law, at least with respect to civil service employees, is the notion of just cause, which bakes into itself a principle of due process and fundamental fairness. So in essence, when an appointing authority is aware of an issue and slumbers on that issue and fails to take timely action, it becomes increasingly difficult as time passes to take action.
Well, that's why, although I don't know what the law you refer to is, but that's why the commission knocked down the penalty. I guess they thought this seems kind of crummy. But I'm having a hard time figuring out what the principle will be. 3 days after they made that internal decision not to charge him or, not to discipline him, they couldn't change their mind?
In a timely fashion, perhaps. And maybe it would never have been known that there was an initial decision not to charge.
Let's say it was known. They call the guy up and someone calls him up and says, listen, we've decided not to go with this. And there's a little more back and forth internally, whatever, and finally someone says, you can't really let something like this go. And they're like, yeah, it's a shame we called him, but, we have to. I'm just trying to figure out, this, it's sort of like prosecutorial discretion or something. But in the case of a criminal charge, of course, there's a statute of limitations. But that's the only limit so far as I know, right? If there's no judgment of acquittal, the question of whether the prosecutor is going to act, I assume, remains open, right?
It distills to a question of fairness, Your Honor, and what is fair in the circumstances.
Well, you show me a case that says you can't prosecute someone within the statute of limitations because it's unfair. I'd be surprised if there's such a case.
Agreed, but in the civil service context, that notion of fundamental fairness, I think, would operate. So if...
Well, but did he receive a written warning in 2012?
He did.
And was that the discipline?
That was the discipline at that time. Now, even if we were to assume that what was known to then Deputy Chief Jebb and then Chief Ferraro in 2012 did not include the Brady letter from then District Attorney Mastriani and now Judge Mastriani, that information about the Brady letter was known to the decision makers in 2013. That was then Mayor...
Do we read into the 2012 written warning that there would be no further discipline?
What would be encouraged by allowing a municipality to look at a situation and advance charges on some aspects of that event, but not others, would be in essence to encourage administrative claim splitting.
Well, but what was the written warning for? What acts?
It was for incompetence.
And so they didn't address the untruthfulness?
The chief, we have in our record, the chief indicated that he did not want to pursue that charge against any officer who was involved.
But the written warning does not speak to that?
It does not speak to it, Your Honor. But then moving ahead to 2013, when then Mayor Bissonnette and then Chief Thomas Charette became aware of the Brady letter, that we have in our record considerable evidence that this was a topic of discussion, that they consulted with counsel, that they did their own, in Chief Charette's instance, they did their own research into what was fair in that situation, and they determined that because the 2012 discipline addressed the actions of GODERE, it would be unfair and inappropriate to charge with administrative violations that the decision earlier had been made not to charge. Going back to Judge Rubin's point earlier, the focus of civil service law is on the misconduct that is alleged by the officer. So the misconduct that's alleged here as to Jeffrey GODERE is the events of early 2012, the report and the meeting with Chief Jebb. There is no conduct by Jeffrey GODERE that's alleged to have been untruthful or inappropriate after that event. And what the commission rightly was concerned with in this instance, and why it indicated that the termination was unjust, was you can have a parade of horribles in which any new administration, a new mayor, a new city council, board of selectmen, chief of police comes into office, reviews the personnel files of civil service employees and says, 10 years ago you received a 3-day suspension for X. I think the suspension should have been 10 days. So I'm now imposing an additional 7.
But isn't our case different? Because here, your client is not being penalized twice for the same infraction. It's from the same set of facts, but he was penalized the first time for untruthfulness and the second time, or the first time not for untruthfulness, but for conduct unbecoming, if you will, and the second time for misconduct. Yes, it arises out of the same set of facts, but I see this as different than the case that you relied on, which is that Springfield case.
But to that point, Your Honor, I think it's exactly on point with the Bliss decision that's in our record from the Civil Service Commission. In Bliss, there was an allegation of misconduct brought against a police lieutenant. In the course of that set of proceedings, the issue was raised about prior uncharged but like misconduct of the lieutenant. And the commission decision was it would be fundamentally unfair, it would violate just cause principles for the municipality to have known about like misconduct, decided not to charge based upon that misconduct, only later to try to reinvigorate that issue. As mentioned earlier, Your Honors, everything that was known in 2017 and 2018, when Jeffrey GODERE first was placed on administrative duties and later terminated, was known to the same decision makers, their predecessors in office, in 2013. They made what the commission found to be a careful and considered decision not to revisit the issue at that time. And the commission rightly was concerned that by allowing the city to terminate Jeffrey GODERE, you would usher in that scenario in which subsequent administrations can revisit, reopen, reimpose discipline.
I'm sorry to go back to the timeline, but the Brady memo, which seems to be the rationale for at least the initial termination, that he's not going to be able to testify in cases, that Brady memo issued 8.5, 9 months after he received his written warning. So that is new, if you will.
With respect to the 2012 decision.
Right.
But when that memorandum came to the attention of the chief and the mayor in 2013, they had discussions about whether it would be appropriate to revisit the discipline in light of the Brady memorandum. They concluded, in what the commission thought was a carefully arrived at decision, they concluded in 2013 that it would be inappropriate to go back and reopen the discipline from 2012.
But what do we have in the record that says that?
It's in the commission's findings. It derives primarily from the testimony of then Chief Charette, who indicated that when he became aware of the Brady memorandum in 2013, he received the copy, he reviewed it. He did his research. He reached out to General Counsel for the Massachusetts Chiefs of Police Association. He had conversations with Mayor Bissonnette. Mayor Bissonnette, we have in our record, made public statements that he was considering the legality of imposing additional discipline upon officers involved in this event. And then we have years of no action being taken.
Do we have any appellate cases regarding discipline stemming from the so-called Brady memo, other than this case?
In the civil service context or arbitration, I'm not aware of any decisions from the appeals court dealing with that.
Or the SJC?
Or the SJC. I do know that we have the testimony of the then district attorney, now Judge Mastriani, who indicated during his testimony that he never believed that his Brady letter with respect to these officers created an impermeable barrier for those officers.
Testimony.
Correct.
Right.
And he also gave some testimony about essentially workarounds for officers who are on a Brady list, meaning those officers aren't assigned to detectives where they are applying for search warrants or arrest warrants. You can minimize the exposure in that way.
Was there some discussion about being a parking clerk or something?
After the information about the Brady list came to the attention of then Chief Jebb in 2017, we have in our record testimony that he had a meeting with Jeffrey GODERE in which he was placing him on administrative duties, and there was discussion about creating a position, in essence, in the department.
Does it matter, or why does it matter, what the discipline was or wasn't for the other officers?
It matters in the sense that, and I know that the city had made some arguments in its brief about the inability of the commission to consider other employees and their disciplinary actions. That's just simply not the law. The law is pretty settled that one of the purposes of the civil service system and a function of the commission is to ensure uniformity of treatment, not only within an appointing authority, but across the Commonwealth. That an officer in a department who receives a reprimand for being late to roll call should not suffer a consequence so light when another officer received a 10-day suspension for the same infraction.
So there's some parity between departments.
Correct. And both Judge Mastriani and the commission concluded, Judge Mastriani in his testimony, the commission its findings, that there was no principled way to distinguish Jeffrey GODERE from the others who were involved in this situation. And one of the, I think, sadly ironic twists in this entire case is that if anyone is to be considered the most culpable individual in this set of events, it's CL. At the end of the day, if Jeffrey GODERE's demotion stands, he was demoted in rank, and CL received 3 days of punishment duty.
3 days of
Punishment duty, working for free, in essence. And one officer received a reprimand, and another officer received no discipline whatsoever. I see that my time has expired.
Thank you very much.
Thank you.
Mr. Hammond.
Sorry.
It's all right. They were good questions.
Thank you, Your Honor. Daniel Hammond, Assistant Attorney General for the Commission. I'm in a somewhat awkward position here, Your Honor, because I'm intending to respond both to Sergeant GODERE's arguments and to the arguments of the City of Chicopee, which obviously is not here.
Well, the city has waived argument, and it's my understanding, too, from the record, that the city did not notice an appeal in this case.
That is correct, yes.
So their arguments about what was done incorrectly by the commission aren't before us.
The Commission did not take that position here. I know Sergeant GODERE did. I can speak to that briefly.
Okay, go ahead.
You know, certainly as the appellee, the Commission...
Double time now, so you might as well.
This is true. I have to fill it with something. The Commission did not participate at the Superior Court level, where, again, Sergeant GODERE was the only appellant. The Superior Court judge did resolve the case on cross motions for judgment on the pleadings, wherein the city made its arguments on the merits, and the Superior Court judge addressed those arguments on the merits.
And they didn't appeal.
I beg your pardon?
There's no cross appeal.
No, there is not.
So why is it the commission's position that we should have anything, hear anything from the city seeking to expand its, what it was given?
I think the only thing I would say to that is that we are here under Chapter 30A, and Chapter 30A permits a reviewing court, obviously, to affirm, to reverse, or to modify the decision below. And so...
I'm not interested. I mean, I'm somewhat interested in the they didn't bring a petition. That actually seems like a pretty good argument, that the city didn't bring a petition in the first instance in the Superior Court. But what do you say about them not filing a cross appeal? I don't understand how, without a cross appeal, we can give them any relief.
Well, certainly, if the court deems that to be jurisdictional, then
that's
absolutely correct.
But your position is that it's not? You have a case that says you don't have to file a cross appeal in a case like this to get additional relief? I'm not aware of anything like that. Call it jurisdictional or non-jurisdictional. It's still a legal rule, right?
It is, and I certainly don't want to get too far out over my skis here, arguing for the viability of their arguments when I'm then trying to knock them back.
Jurisdiction or not, and help me if I've got it wrong, but you represent the commission.
I do.
So the city's taken issue with a few things the commission did.
Yes.
But if those aren't before us, why would you, on behalf of the commission, try to convince us that they are before us?
If they're not before us, then clearly there's nothing to discuss.
Okay.
And I'm not trying to...
That's not his question. His question is, why are you arguing that they are before us? It's the commission's position that every party, because something was modified, can, without filing a notice of appeal, as long as someone appeals, we can then kind of just muck around in here? I don't really understand.
No, certainly not. I'm just trying to, I guess, explain why the commission, having not participated before the Superior Court, jumped back in here because its powers to modify were clearly before the Superior Court. The Superior Court spoke to them, and we felt it necessary to advise the court as to our view of those powers. I'm certainly not going to try to resurrect a quasi-appeal that was never taken.
Okay, thank you.
So
Thanks for that helps. Thank you.
Thank you.
So I want to now ask you about what you're here for.
Certainly.
I have to say, it is troubling to me when I go through the timeline that 6 years later, he's at least initially terminated and then modified to a demotion. I couldn't find any cases on point, but do you agree that in 2012, he received a written warning that was not for untruthfulness in the IA investigation, but that related to the photo in the homicide?
I do, yes.
So that when he's later terminated for untruthfulness, and I understand that the commission reduced that,
Yes.
it is from the same set of facts, right?
It is from the same set of facts.
So
but
I know
not
we
the same-
don't
I'm sorry.
have, your brother calls it industrial double jeopardy. It does trouble me that a new chief can go back to a set of facts from 6 years ago and say, find a way, if you will, which is what it felt like in reading the administrative record, to get rid of this guy because he was concerned that he wouldn't be able to testify. Are there any cases that speak to this one way or the other?
Not specifically about either the time lag or the sort of severable pieces of the same set of facts. As Your Honor suggested, there was the incompetence, the use of the cell phone, the compromising of the crime scene. That's what he was ultimately disciplined for. And then there was...
You would agree he couldn't go back, he being the chief, I'm sorry,
Yes.
on the incompetency 6 years later and say, you know what, a written warning wasn't enough, I'm going to do X. Could he take further discipline on something that the officer already received a written warning for?
Absent additional intervening facts coming to light, I would say no.
Okay.
But that is not what happened here. But actually, I want to step back for a minute just to frame what the commission did here, because I think this might help. And again, the commission was here under its enabling statute, Chapter 3143, which essentially tasks the commission with doing two things. The first is fairly straightforward, which is it has to determine whether there was just cause for the appointing authority to take action against the employee. And the case law has fleshed that out and said that basically just cause means, was there a preponderance of evidence to suggest that there was substantial misconduct by the employee that adversely affects the public interest? That's basically a factual inquiry. The question, to be very colloquial about it, reduces to, did he do it?
Right.
And so the commission held a de novo hearing, heard from all the witnesses, including Sergeant GODERE, made credibility determinations about everybody who appeared in front of it, and ultimately said, yes, he did it. And the commission, in excruciating detail, walks through the elements of, or not the elements, the chronology of the investigation, when Sergeant GODERE was first contacted by Deputy Chief Jebb, what he said to him, how he ultimately changed his story. And one fact that the commission found very telling was that while he had said on several occasions that he could not recall either who sent him the photo or whom he sent it to, the deputy chief sort of called his bluff. And
Right, and he kind of had a mea culpa and came forward.
Right. He invited him to get his cell phone records, to refresh his memory. And at that point, I'm sorry, I don't mean to cut you off.
No.
But, I was building toward, the fact that the commission found very significant here was that when he ultimately acknowledged that he did in fact remember and told Deputy Chief Jebb whom he got it from, whom he sent it to, he prefaced that by saying, I don't want to be seen as a rat. And so...
Was that after the chief told him to check his phone records?
It was.
Okay.
Yes.
So
I'm sorry. So the implication was it wasn't the phone records that refreshed his memory. He always remembered, but he didn't want to tell. And now he was kind of backed into a corner.
And that's the untruthfulness.
So that's the untruthfulness.
But is there a bright line? And I'm guessing your answer is going to be no, but
Right.
Could they have waited 10 years? Could they have waited 20 years? I mean, how long, when a civil servant my words, not yours, screws
Sure.
up, how long is this sort of Damocles hanging over their head? Forever?
Well, there being no statute of limitations, I would say no, there's no limitation, but I would put the caveat in here, and building back to my original point, there were two things going on here. The first was this just cause inquiry, did he do it? But the statute also contains the sentence at the end that says the commission may also modify the actual discipline that is parceled out by the appointing authority. Statute doesn't really talk about the standard for that or when it can do that. The case law has, and we quote at length from this court's 1996 decision in the Boston Police Commissioner case. Essentially, this is where all the equitable arguments come in. Okay,
And that would include the time that has passed.
Exactly. He did it. Was it fair? And when I ask was it fair, the courts have also been very clear that the Falmouth decision from the SJC is very clear.
I don't really see this. The question of modification, in my view, isn't before us. Obviously, we haven't deliberated about that.
Sure.
But since the city didn't file a notice of appeal, it seems unlikely to me that they can prevail on that question. But there's a mismatch, it seems to me, between what Justice Blake asked you about. Can you wait forever? To which your answer appears to be something like yes. I don't understand why that means, but you have to modify the punishment. The punishment is a consequence of the infraction. If the infraction warrants firing, then it does. If it warrants demotion, then it does. If it warrants a warning, whatever it is, right?
Yes.
The fact that you get it 10 years later, it seems to me, is much more relevant to the question, can we do anything about this? It was 10 years ago. Then, oh yeah, of course you can do something, but firing seems a little harsh. Right? I mean, if he had murdered someone or something, we wouldn't say, oh, that seems a little harsh to fire him for that. And we wouldn't say, oh, but it was 8 years ago, so it seems a little harsh. It seems to me that the real question you have to face is there an outer time limit? Is there an equitable principle here that says you can't wait 6 or 7 years and discipline somebody? Or you can, and you've said you can, although then you give all these quite good reasons, length of time, new political administration, which I understand that we haven't had clear citation to, but if indeed the commission is correct that that's what the civil service law is supposed to protect against, you don't solve the problem by changing it from firing to demotion. You solve the problem by not allowing them to discipline him that much later after an election. What's your response to that?
I would say that this is really more of an argument about whether the punishment fit the crime than whether, and again, this is not a criminal matter, I'm speaking
But it's not really. If it had happened the day after the lying in 2012, you wouldn't have said the punishment didn't fit the crime. You'd have said, all right. What you said, or what the commission said was, but it's 6 years later, that seems wrong, no citation, right? And then it said, like, we're supposed to avoid this thing where new politicians come in and do something about it. Those don't say, therefore, demotion. Those, it seems to me, mean so you can't do it, or you can, whatever the answer is. Why can you do it? Why can a newly elected politician 6 years later, how does that protect civil servants? To let the newly elected politician, for political reasons, go after someone, A, and B, how many years does it have to be before you would say you can't do that?
Well, I guess what I would say to that is it was an offense that clearly had a tail to it because of the Brady Memorandum. And
that had been in place for 5 years. Right, the Brady Memorandum, by 2013, everyone knew there was or if they looked, they would have known there was a Brady memo, right?
Well,
the prior administration knew,
prior
right?
administration was aware of it, yes.
Okay, well, that's right. I mean, do you stand by the commission's position that electing a new politician isn't a good reason for disciplining a civil servant, or you don't think that's right?
Well, it was one of multiple factors that the department, that the commission laid out for why it found the discipline to be too hard.
You see no legal bar, though. All you see is a kind of mushy, so let's knock the punishment down.
Well, I think there would be a legal bar, as per Justice Blake's earlier question, if he had been disciplined for this offense back in 2012, and a new administration came in and said, you know what, we don't like this guy. We're going to add an enhancement.
Why should we
to the
take the
2012
approach
penalty.
that Justice Blake's question takes as its premise, that one is for the use of the phone and the other is for lying about it, instead of saying these all arise out of the same set of operative facts? And this is just as barred, which we might do if we were really doing res judicata, right? We might say these are actually the same case, even though I understand there's some temporal issue about when was the use of the phone and when was the lying about it.
Right. But it's from the same sort of macro set of facts.
Sure.
But there was the offense, and then there was the attempt to cover up the offense.
Yeah.
He was sanctioned for the offense.
Okay.
He was never sanctioned for the attempt to cover it up until 2018. Yes, I would say there is no temporal bar there. The question before the commission was there substantial misconduct? Answer, yes. Then it went to the secondary question, which is, okay, the sanction that was applied by the city, was that an appropriate sanction given all the circumstances of the case? And the commission laid out all the reasons why it thought that was excessive and reduced the sanction. I see my red light is imminent, so if there are no further questions.
Thank you, Mr. Hammond. Thank you both.
Thank you.
We'll take it under advisement. Thank you. The next case is 22P442 Commercial Credit Group Incorporated versus Kerosey. Mr. Hickson.
Yes. Members of the panel, may it please the court. Excuse me, my name is Jonathan Hickson, and I represent the Appellee Commercial Credit Group. Your Honors, this is a relatively simple and straightforward case relating to the enforcement of a default judgment in North Carolina here in Massachusetts under the full faith and credit clause of the United States Constitution, Article 4, Section 1. This is not a case, contrary to what the appellant argues, about Mr. Kerrissey's liability and the extent of that liability under the guarantees that he executed in favor of my client. That matter was decided by the North Carolina court in that case where Mr. Kerrissey consented to jurisdiction in the guarantees, where he was served with process in accordance with North Carolina law and the North Carolina Rules of Civil Procedure, where he failed to show, which are not disputed facts, he failed to appear and defend that case.
He can't challenge the North Carolina judgment here.
Correct. That is basically the premise that we submitted on summary judgment. He has attempted to collaterally attack that judgment, and that is the basis for his appeal. He shifts the arguments that he makes somewhat on the to the trial court here, to the appellate court, to now focus on these issues of facts that he claims. But those are relitigating the issues on the North Carolina judgment. So we don't believe that that is a proper argument in front of this court, that we believe the motion judge properly ruled on enforcement of the North Carolina judgment here.
And that's why you're seeking fees here?
That's why we're seeking fees here. They're warranted under the contract, yes, Your Honor.
Which provision of the contract was that?
It's part of the language in the guarantee, which is, I can give you the record citation.
I didn't see that argument. I saw the request for fees, but I didn't see that you said that was why you wanted them.
It may not be in there. I believe that's why we.
You said it was under Favory Walton that you were asking for fees.
That's just the mechanism.
I stand corrected. You're right, Your Honor. That is why.
But does the guarantee provide for
Yes.
fees if you're successful?
Correct. The guarantee.
You get fees below?
Yes, we did.
We've changed the rules, well, the SJC changed the rules of appellate procedure. You have to not only request, but you have to cite the authority in your brief for the fees.
Right.
Understood. I believe, so, meaning in addition to the Fabre v. Walton, we have to cite the authority. So the guarantee is in the record.
Fabre versus Walton is not the authority. It's the mechanism.
Understood. So the authority then would be the guarantee.
Like it was under 93A or whether there's a specific rule.
It is under the guarantee itself.
No, I understand what you're telling us
Okay.
now, but that's not in your brief, is it?
No, it's not, Your Honor.
Thank you.
You're not seeking fees because it's a frivolous appeal, you're seeking them under the guarantee.
Correct.
Okay.
So with respect to the remaining issues, the factual issues that he raises, as I said, are an attempt to relitigate the underlying North Carolina guarantee. With respect to the issue as far as consolidation, I would argue the same arguments as to relitigating the North Carolina judgment apply. The motion judge correctly concluded that there are no common issues of fact because the underlying judgment was already determined in North Carolina. The only issues that are relevant for the judge and for purposes of deciding consolidation were subject matter jurisdiction, personal jurisdiction, which he decided and which were undisputed. So for that reason, the judge didn't abuse his discretion as well on the motion to consolidate. I have really nothing further at this time, Your
I
Honor.
was just going to say, you don't have to use all of your time.
If you have any other questions, I'm happy to answer them, but otherwise,
Seeing none, thank you very much.
thank you.
Our next case is 22P580, Roberto Cruz versus the Commonwealth. Mr. Hornstein.
May I proceed, Your Honor?
Yes.
Thank you very much. Adam Hornstein, I'm an Assistant Attorney General. My pronouns are he, him, and I'm here today on behalf of the Commonwealth, asking this court to reverse the decision below because the appeals court decision vacating Mr. Cruz's underlying criminal case did not tend to establish his innocence of all crimes charged in the indictment as is required by Chapter 258D, Section 1B.
So I have some questions for you.
I hope I have some answers for you, Justice
I hope
Blake.
so. The only case that I found that I think, and both of you cite, dealing with a reversal on sufficiency as it relates to this statute is Renaud.
Correct.
Do you agree?
Renaud, I think, is a critical case, Your Honor,
Okay.
yes.
Well, in reading your brief, my initial impression is that maybe you have conflated the eligibility with the merits. And I know you're going to say you didn't, but I want to ask you sort of a different question, which is, if we were to agree with Mr. Rappaport that the sufficiency allowed him to walk through the eligibility door, not the merits, but the eligibility door, one thing I haven't found, and I don't think either of you cited a case that we are presented with here, which is where you have a reversal on sufficiency for one charge and then the A and B, which is null prost. I have not found a case that deals with this construct of facts. And if I read the statute correctly, the fact that the A and B was null prost does not open the door to eligibility for him, notwithstanding the reversal on the indecent A and B.
Okay. I think there was a few negatives in there, so I'm going to try to answer your question and address your concerns, but if I completely whiff, please steer me back in the direction.
Okay.
So the court is correct in observing that for sufficiency of evidence type cases under Section 1B, Renaud is what we have. The closest analog that I can give you, again, it doesn't arise specifically in this context of sufficiency, but that dealt with either alternate theories of a crime or other conceptions or avenues to conviction, that would be the Fragata case.
Right, and that's unpublished, but Fragata
Correct.
was reversed, as I understand it, on different theories under the intimidation of a witness statute. What
Yes.
we're talking about here is different. This gentleman was indicted for indecent A and B and A and B, and for whatever reasons, the government chose at the time of trial not to proceed on the A and B. So I think that these facts are even different from Fragata. So have you found a case addressing 258D 1B little 2 with this fact pattern? Or is this case a case of first impression?
If we are being that targeted, Your Honor, this case is one of first impression. However, I think the Renaud case is instructive here because it fits with, again, the Fragata decision, the Guzman decision, the Irwin decision, Santana, Riley, Peterson, et cetera, that are all consonant, which is that the unique facts and circumstances of the case as recited by the judicial relief in the criminal case is what is important. And if those facts and circumstances, in other words, that holding, the attendant circumstances of that case are probative of the proposition that plaintiff, are probative of the proposition that plaintiff did not commit the crimes that were charged, then he is eligible. If not, then he is not eligible. And respectfully, Your Honor, the Commonwealth's position here is that the court, in the underlying criminal case, it recited these unique facts and circumstances, namely that there was testimony that plaintiff took the victim into a secluded room at the airport, began to give her unwanted hugs, and began to lift her shirt before she was able to get out of that room.
We reversed that case on the question of sufficiency of the
Indecency,
what
correct.
the touch was. But I think Renaud also hurts you. At 316, the SJC said, "We transferred the case here on our own initiative to determine whether, under the statute, the reversal due to insufficient evidence amounts to, quote, grounds which tend to establish his innocence, rendering him ineligible. We conclude that it does." So I think if we only had the reversal on the indecent A and B, I think this squarely falls under Renaud, and he's in. Not on the merits, but on the eligibility. So I'm really focused on the A and B that was null pros.
Okay, so let's continue on with what Renaud says in
Okay.
that case. Again, Renaud was emphatic. There can be no categorical rule. So I don't think Renaud was saying that anytime you get a dismissal of a criminal case or a vacation of a conviction.
And I think your brother concedes that in his brief. There is no categorical
Well,
approach.
let's be careful about the verb, too, dismissal versus finding insufficient evidence. And
Very good.
I had a similar question about the categorical ban, and I took it from your last answer that you don't read Renaud to create a categorical qualifier for insufficient evidence, because
Correct.
one would have to conclude that insufficient evidence is synonymous with innocence.
Correct. And I think
which it's not.
Which it's not. And I think the facts of Renaud, and this is where I'm going to address Your Honor's question, Justice Meade and Justice Blake, is let's look at the facts of that case, where the facts that ultimately led to the determination of insufficiency had to do with the identity of the criminal defendant. In other words, the facts weren't sufficient to say, you were the guy. Here, that isn't an issue at all. The
Okay,
facts,
but the rule that you're arguing for, I feel like you're underplaying this phrase "tends to," and I think you're underplaying the fact that this is nothing but a question of who can even file a suit. You can move to dismiss for failure to state a claim. You can move for a summary judgment. I don't know what the facts will show, obviously. But it seems to me that if you were right, and the Commonwealth charged someone with 8 counts, as they often do, and dismissed 3 of them before we even got to trial, and the person is convicted of the crime, and the SJC doesn't even say insufficient evidence. I mean, let's start with that. They say, there's no evidence here to support this conviction. Obviously, they're not going to mention dismissed claims that were never tried or brought, but they're in the indictment. I feel like you'd be here saying, oh, it doesn't tend to show he's innocent because it doesn't even mention the whatever claim you can call, the driving without a license claim that we also had in here, and the this and the that. I find it hard to imagine that that's what the legislature had in mind when they said people who are kept in jail wrongly, convicted wrongly, and are factually innocent can recover. Now, he may not be factually innocent, but I don't understand why you don't have to defend the claim or why he isn't allowed to show he has the burden. I'm not saying that it's clear and convincing evidence. You may well win, but I don't understand this. It seems to me a decision that says no sufficient evidence on the thing you were convicted of, the only thing that went to the jury, or in this case the judge, that tends to show that you're innocent. You may well not be, but it tends to show you're innocent.
well, let's look at what the legislature says, because I think that is important here, and it's something that, for example, Chief Justice Gantz highlighted in his concurrence in the Peterson case.
Concurrence.
Correct.
Okay. I mean, I've read these cases, what are they, Irwin, Renault, Guzman, and they all seem to say this isn't about the merits.
Correct. It is,
Right.
again, I want to be clear here. This is not emphatically about the merits.
Yes, but your argument basically goes all the way down to the merits. An unprosecuted count, he isn't factually innocent of that. Well, how the heck do we know? Go have a trial about it.
Let's look at what the legislature said. Again, 1B, and I think this is what Justice Blake, you may have been tipping with your first question. This eligibility threshold jurisdictional question, it incorporates some of the language from Section 1C, which obviously is the core gravamen merits of the claim. It says, in order to be eligible, a claimant has to show that their conviction tends to establish their innocence within the meaning of Section 1C. 1C, in turn, incorporates not just crimes charged in the complaint or indictment, but also uncharged claims, anything that is related to or arising out of the facts of the crime or crimes charged in the indictment. So, respectfully, Your Honor, the threshold jurisdictional inquiry depends, according to the legislature, not me, according to the legislature, depends not just on the crime for which the conviction was overturned, but this host of other things as well. And Peterson reminds us, just as Guzman did, just as Irwin did, just as Drumgold did, that this jurisdictional requirement is meant to serve a screening function, which is to say that necessarily there may well be somebody out there in the world who can prove by clear and convincing evidence that he is actually affirmatively innocent of the crime for which he was convicted. I had this trial. It was the Stevens case. But in that case, the jury found that although he was actually innocent on that one crime, there was another related crime that he wasn't innocent for, and thus he lost his case at trial. But again, this highlights the idea that this jurisdictional bar is a screening mechanism, and that not everybody who can prove actual innocence gets to even come to court under the jurisdictional bar.
The case you just talked about was on the merits. The person did get to go to court, right?
Correct. I'm
All
using
right,
it as an
somehow
illustrative.
they got through the jurisdictional screen even though they weren't factually innocent of one of the crimes. So I guess sometimes the screening mechanism lets people get a trial.
Well, the screen is permeable, perhaps, but in this case, Your Honor, I want to make clear, again, let's look back at what the appeals court actually says here, because I think it is illustrative, and I think it is...
Well, can you first answer my question?
What was your question?
In
I'm sorry, I
addition
apologize.
to all of the crimes charged in a case, there's also driving without a license or with a tail light off, or I don't know if it has to be a misdemeanor or a felony. It's in the thing, but it's dismissed before anything.
Yes.
Because there's serious crimes involved, guns, drugs, whatever.
Sure.
And now we get a decision from the SJC on the only thing that ever goes to trial, and it is this guy, let's have it even be clear, this guy's factually innocent. You don't think that tends to show he was factually innocent of the things he was charged with, even though it doesn't show anything at all about whether he had a license or not?
I think under Raynaud, I would need to know one other critical fact, which is, it's not just the SJC has decided he's actually innocent of the murder in the court's hypothetical, but do those unique facts and circumstances as recited by the SJC also tend to establish that he didn't commit the crime of driving with a busted taillight?
No, they don't mention it at all, of course, because it was dismissed prior to trial by the Commonwealth.
Sure.
And so it never went, there's not even any evidence about it.
If that were the case, Your Honor, I would fully recognize that that is a much closer situation than what we have here.
And which way does it come out?
I'm sorry, Your Honor?
Which way does that one come out?
Which way? That one is much closer to the plaintiff being eligible.
But it's not eligible, it's just closer.
It would be, that is a very marginal case, Your Honor.
But it's not, I'm just asking you, is it eligible or ineligible?
I would say that as Your Honor has constructed the hypothetical, that likely would fall on the eligible side of the spectrum.
How? How can that be? The decision doesn't say anything about whether he had a license or not.
Correct. If there is a complete and utter vacuum, I think we, again, under Peterson, under Irwin, under Guzman, are compelled to look at the text, the four corners of the decision. And the four corners of the decision in this case, in Mr. Cruz's case, are emphatic that the behavior towards Jane may have constituted the criminal offense of assault and battery. That's
And
what
then Justice Milkey amplified that in the concurrence.
That was the next sentence out of my mouth, Your Honor. Absolutely. Justice Milkey didn't just say that. Justice Milkey said that the illegality of Mr. Cruz's conduct here wasn't even at issue because they were deciding that indecency had been drawn too broadly. So yes,
I have great admiration for my colleague, Justice Milkey. And if he had gotten another judge to go along with him, maybe we'd have something to talk about.
Well, he did join.
Well, the majority also.
The majority says it as well. Justice Milkey
It
just takes
says
it
may have prosecuted him for. Of course, they may have prosecuted him for.
Which is not, that if a may prosecute isn't things that tend to support innocence, though, is it?
I would certainly hesitate to say that when the majority says that behavior towards Jane may have constituted the criminal offense of assault and battery,
Are we supposed to look at why the Commonwealth might have null-prossed this?
I don't think that matters. The only thing that matters under Section 1B is not the Commonwealth's motivation, but the text of the decision itself.
Of the decision of the SJC, even though anyone might think, oh, after you presented all your evidence, you null-prossed this, you must have thought it was insufficient.
I think, again, Justice Milkey speculates as to why the Commonwealth.
Yeah, but Justice Milkey wasn't there.
Correct, but it's a
and
matter
he's
of
never been a
prosecutorial
prosecutor for that matter. Why would you null-pross something after presenting your evidence, except that you thought it was insufficient?
Well, the Commonwealth did this before any evidence was presented, and
no, I think it was at the close of the Commonwealth's case.
I apologize, Your Honor. Irrespective, I think that we cannot second-guess the prosecutor's discretion in deciding to, as a matter of strategy, proceed on one.
Okay. I mean, your time.
I see my time.
I think
is
you
up.
see my concern.
Thank you very much, Your Honors.
Mr. Rappaport.
Good morning. To please the court, let me just begin with what Justice Rubin was just asking about. First of all, I wouldn't dispute that the physical acts of Mr. Cruz in this case may have constituted an assault and battery. But there's a big step from what it may have been to what it was. There was never any decision that this was an assault and battery. In fact, we know that there was never any evidence in this case allowed on the issue of consent or lack of consent. Now, you just asked the question about the null
Well, there
process.
was evidence that the victim had Asperger's, right? And that her age and perception, if I remember correctly from the underlying criminal case.
She had Asperger's, Your Honor, but
And she was alarmed.
some cues she said she got. She was a little unclear on
She
some
said
cues.
she was
but
uncomfortable. It felt like the hug her parents would give her, not a stranger.
Well, it went like this. He wanted to give me a hug. I said, okay. He asked me for a second hug. I said, okay. I wasn't alarmed by the second hug or the kiss on the neck. He asked for the third. The third hug was without my permission. It was like a hug from my parents. He then asked me to turn around. I turned around. He said, you're tall, and left. But here's what I would submit is really significant here. First of all, before at volume 3, page 99 and 100, in the pre-charge, the judge tells the jury that consent is not an issue. Assault and battery is a lesser included offense of indecent A and B. But then at 158 of that same volume, the prosecutor tries to get into the issue of consent and says, did you want the defendant to kiss your neck? She says, I didn't ask for it. The court there then interrupts and says, doesn't matter whether she wanted him to. Consent is not an issue, ladies and gentlemen, at all. The Commonwealth's question was irrelevant. Then you go to the defense attorney on cross-examination.
But was it stricken?
Yeah.
Yes. Well, I don't know that it was stricken, but at that point, the judge told the jury, you're not even to consider the issue of consent. Then, when the defense attorney asked the question with regard to the touching, did you push his hand away? The Commonwealth objects, and the court says sustained. Consent is not an issue, ladies and gentlemen. So the issue of consent was never reached by the jury below. And in addition to that, you know, there was an enticement charge in this case, and the defendant was found not guilty of enticement. Now, I recognize that there's no lack of consent or consent element, in factual element with regard to enticement. But what it does indicate is enticement is very simple. He asked her to do something. He asked her to go into a room. She was under 16. We know all those three things exist for the enticement, but then the fourth is that he intended to indecently assault her, or he intended to use force against her, and if we consider that A and B may be...
Where we started with Justice Rubin, and I think where I started with the prosecutor, the statute at 1C(6) says, a claimant must establish that he did not commit the crimes or crimes charged in the indictment. And I watched you shake your head when I asked if anybody found any cases.
There is no case.
There is nothing, right?
This is the nuance of this case that really sets it apart from every other case.
So help me get to where you come out on this. If we agree that, for the sake of this question, we're on a blank tablet as to or crime charged.
If the defense attorney and the prosecutor on the appeal of Commonwealth versus Cruz had briefed the issue, that would be one thing. At least you get an advocate for both sides saying this is what exists or this is what doesn't exist.
We did speak to it in the majority, and the concurrence amplified it. So there's a record.
What the majority says, and it's very interesting because my brother in his brief keeps talking about the emphasis in the main opinion. At footnote 8, what the court says is the defendant's conduct may have constituted simple assault and battery. Certainly, the acts that were committed may have, but consent was taken out of the case. The acts themselves are not criminal. Even if we say they were creepy, that's not a crime.
Well, she
and
did
in fact,
testify.
even in his concurrence,
she did testify, counsel. She felt a little bit alarmed and thought your client's behavior was kind of odd.
And I wouldn't dispute that it was kind of odd. It wasn't criminal.
How long was
It
her...
wasn't indecent.
It certainly wasn't
They said
indecent.
it wasn't indecent.
And we never, ever, in any respect, had the opportunity to indicate whether or not it was consensual or non-consensual because the judge took it out of the case. Now, one of the questions you asked of my brother was, well, why was the case null prost? And let's go back to Judge Liu's decision below. It was null prost because there was no evidence when the case went to the jury. The case was tried, but when the case went to the jury...
Please stand in front of the
I'm
microphone.
sorry, when the case went to the jury...
We're not the jury, though.
I'm sorry.
So, tell us what is in the evidence about the reason behind the null pros.
The reason for the null pros was there was no evidence of consent. Is that in the record? Initially, Judge, when I looked at this case, I thought there may have been some prosecutorial overreaching. Frankly, I mean, it's...
All right, let's go back to my question, Mr. Rappaport, is it in the record why the case was null prost?
There's no statement by the prosecutor, I am null prosing this case because...
Because I can think of another reason why they null prost it. So,
Well,
it's not, which isn't in the record either.
That's true, but I'm talking about my initial response to what happened here was perhaps what you're thinking the reason for the null pros.
You're speculating on what the reason is to negate the applicability of the eligibility clause.
With regard to the null pros, I don't think I'm speculating at all, Judge. There was
You told us it's not in the record.
Well, but there's no evidence with regard to an essential
But this
element.
doesn't matter anyway. I mean, I'm the one who brought this up. But this doesn't really matter. We're supposed to look at this judicial decision and decide if it tends to show factual innocence, tends to. Now,
It's-
I have a hard time seeing how, obviously, the decision tends to show factual innocence of the serious crime charged in the indictment.
Crimes of conviction.
I don't see how one can look at that footnote 8 and say, oh, I thought this decision tended to show innocence, but it doesn't tend that way at all because of this paragraph. It might tend a little less, but it still tends toward innocence, and that's all we're asking here. And I don't, so I mean, the null pros thing, it's true, one of the parties, maybe it was the Commonwealth, but I may be wrong, suggested in the brief that the reason for the null pros was a tactical decision. I remember reading that somewhere, and I thought, well, that doesn't sound right to me. But I don't think, I agree, I think, with your brother, that that's not really the issue. The issue is what the judicial decision says.
I agree, Judge. And with regard to the judicial decision says, why didn't the Commonwealth take what would have been appropriate if they could and continue the prosecution on the
How long was your
battery?
client in jail for this crime he didn't commit?
Excuse me?
How long was he in jail?
Approximately 3 years.
3 years in jail, all right.
And when I say 3 years, Judge, this is 3 years on a sex crime, a Latino on a sex crime in state prison, which is really
But to be
different.
fair, it was a subsequent offense. That's why he got, there was a
Of which he was
mandatory minimum.
of which he was innocent.
But he didn't do it. The crime wasn't committed, Judge. He was
Innocence
sentenced
is,
for a crime
this
that didn't
isn't
occur.
innocence, this is insufficiency.
We don't put people in jail for insufficient evidence, at least in the United States, so far as I'm aware.
But as
We
I
did here.
So Renau was an identity case, right? Peterson was the motion to suppress the knife.
Yes, that's
Okay.
correct, and it was not reached.
And those came out different ways, so,
Well, Peterson, the court just didn't address the question of guilt or innocence. It never
because
addressed it.
it reversed on a motion to suppress.
That's correct, and that's why we have the Gantz concurrence that the court should be careful.
Are you familiar with the two Santana cases out of this court? They're different Santanas. One was.
Yes,
15
Santana number,
The 15, the one was 2015 and one was 2016.
in fact, Judge Liu below relied on Judge Wilkins' opinion in the 2015 Santana case at 88 Mass Appeals Court. That was the case that spoke about insufficient evidence of possession
Right.
to convict, but it didn't mean that there was a factual innocence found on that particular charge.
But you don't disagree. In that case, the appeals court said, we do not discern a legislative intent that the determination of eligibility be tantamount to a testing of the merits of a claimant's case.
And I would submit that's based on Renault and Guzman. That's correct.
And Guzman?
Guzman
Okay.
as well, because I was appellate counsel on Guzman, and I know why it was dismissed in the Superior Court. The judge at that point thought that it had to be like a DNA type of dismissal
Okay.
at that time. But the fact in this
So
matter...
what's the next step? If this decision stands, the next step is discovery?
We've already completed discovery. We've already done our pretrial conference. We're ready for trial in this case. And what happens next in this case is the defendant, I don't think there's any
No
question.
motions for summary judgment?
Well, I think this was treated as a motion for summary judgment.
Okay.
Judge Liu denied the Commonwealth's motion for summary judgment. So the outstanding issue of fact is consent or lack thereof.
So next up is trial?
Next step is trial, and what the defendant is going, what the claimant in this case is going to have to show by clear and convincing evidence is that he didn't commit an assault, a simple assault and battery. And the issue, the factual issue in that case will be consent.
The judge denied summary judgment on the question of consent.
No.
The judge says there's a genuine issue of material fact on consent.
He indicates that, correct.
Well, if he was provided a summary judgment motion, but instead dismissed it on this jurisdictional ground about the judicial decision, you're saying he did not or she did not allow summary judgment on the alternative ground. There's nothing to go to trial about because consent is clear. There wasn't any. Therefore, he doesn't get a trial. It can't be shown that he was factually innocent. They're not saying that.
What the judge said in his opinion below was that the Commonwealth never established lack of consent in this case.
Even in the summary judgment record.
In the summary judgment, is that the Commonwealth never
All right,
established
but I'm not
lack-
asking about what they established at trial in the criminal trial. I'm saying in this civil action, where the ultimate question will be, was he factually innocent of all the charges in the indictment? The court found that there's a jury question about consent, or maybe even less, that the Commonwealth has not put in adequate evidence to show lack of consent?
The Commonwealth did not put in adequate evidence anywhere to show lack of consent.
Well, but in fairness, what you're referencing is a footnote that Judge Liu dropped in his decision at footnote 3, that the prosecution could not have proceeded on the theory of simple assault and battery due to the lack of evidence of non-consent.
That's true.
Well, wait, but I'm asking
That's a
about
footnote.
summary judgment in this case. You say you've done discovery, so presumably the victim has been deposed?
No.
How did you do summary judgment without deposing the victim? I don't understand. Doesn't the Commonwealth have to, well, maybe that's
I'm
more
not
for
the
your
Commonwealth.
brother. If you move for summary judgment, you must have put some...
I didn't move for summary judgment.
I see. All right.
What I'm saying, the Commonwealth moved for summary judgment on the record before the court.
As it was, okay.
On the eligibility threshold.
Merely
Wait,
on the
on the
eligibility.
eligibility question or on the merits?
Eligibility only.
Eligibility only, all right. Okay.
There are no further questions?
Seeing none, thank you.
Thank you.
Yes, keep going.
Do one more? Sure. The next case is 22P312 Shepard, Kaplan, KROCHUK versus Borzelieri.
Perfect.
Usually I practice ahead of time. This case is partially impounded, my slip tells me, so I'm not sure why. It's partially impounded.
Yes.
I'm not sure why, but
What parts of the record were impounded and the reasons for, I can't speak to, and I don't
okay,
think
you are
material-
you're Mr. Altman, so
I-
okay, please proceed.
It looks like just one volume was impounded.
Okay.
Volume 5.
Let's not refer to the impounded stuff.
Good morning, Your Honors. May it please the Court, Stephen Altman for the appellant, Dr. John Borzilleri, and it's a privilege and pleasure to be here. Thank you for admitting me pro hoc vice. This appeal is from a trial court decision which granted summary judgment dismissing my client's claims for wrongful termination. We submitted in our brief the reasons why I submit that the trial court's decision was an error, the finding both as a matter of law and based on an alleged admission by my client that he committed insider trading. I submit that the record is replete with evidence that in fact, not only is there a question of fact with respect to lack of insider trading, there was no insider trading. And if I may, walking the court through the timeline might even further illuminate that and make very clear that that's just not what happened. The matter starts in really the pertinent facts on November, December 2015, when my client had completed a very extensive investigation with respect to Big Pharma. He believed a massive price scheme had occurred, and he had researched it in detail.
We are familiar with the facts of the case. Your use of the word replete seems a little strong to me.
Okay.
But there is this email attached to this affidavit. And it says that on April 20, 2018, the very day, in the very conversation in which Tim KROCHUK told him that they would separate, although I gather your client says he didn't understand that to mean terminating his employment, but okay, that SKK was, quote, no longer concerned about the insider trading after reviewing the key TAM documents, unquote, but that SKK's, quote, major concern was some kind of defamation sued by key TAM defendants against SKK. Now, I gather your client represented himself below.
Yes, he did.
Perhaps if he had pointed to this with the kind of arrow that I've just used, we wouldn't be here. So I guess the question, and I'll ask your brother this too, is that waived, or is it in the papers below enough that it's not waived?
It's in the papers below that it's not waived, and in fact, there's other evidence in the record which makes clear that there is a factual divergence with respect to what my client said happened during April of 2015 and May of 2018, and May of 2018 with respect to his termination. They said one thing once, they said one thing other. Those are factual issues. Justice Rubin, I'm arguing even stronger than that the record makes clear that, and the judge's finding that he committed insider trading is just
There
wrong.
are shifting explanations which can be some evidence of pretext. Okay. They don't have to be right that it's insider trading, right? They can say, gee, this looks like insider trading, you're fired. And as long as it's not about the key TAM action, there's nothing to talk about here.
I agree 1,000%.
All right, so maybe it's insider trading, maybe it's not, maybe it was material and non-public, maybe it's not. How am I supposed to know? Right? So to me, the important thing is, shifting explanations, one of which is we're concerned about retaliatory or responsive defamation actions. That seems like enough. But again, it really wasn't argued this way to the judge below.
There is no question. And I appeared before Justice Davis, and we started to try the rest of the case. And he's a terrific judge and handled it eloquently. And I agree, as you did, had my client not represented himself and had not necessarily me, I'm nothing special, but a proper advocate, that we may not likely have had the summary judgment decision that brings us here today. I do believe that. But we are here, this is the record, and I'm making the arguments that are presented on this record. There's a sharp divergence with respect to the facts. Dr. Borzilleri, in addition to having for 3 years previously told everyone at SKK about his detailed investigation, had every month sent out to their investors under his name and their name the details of the investigation, had been communicating with the public with respect to the details of his investigation. The information the fact that he was doing that, he disclosed that information. All this is in the record, and we have record sites in our briefs, that he disclosed that to the AUSAs who are prosecuting or considering prosecuting the key TAM cases. The only fact that wasn't disclosed to SKK management was the fact that the key TAM case had been filed under seal, and that he didn't disclose to SKK management because he was federally barred from doing that. He was a rule follower, not a rule breaker. What the record shows.
But just because you and I can sit here and say, well, the press release about whatever you don't call it a press release, whatever it is, this document that announces the key TAM actions are going to be unsealed, or whatever it says, or have been, I don't remember the order. You and I can sit here and say, oh, there was no way that was going to move the market, given all the things that he'd done before. It's nothing new at all. But who the heck knows? I don't know. I watch the market move all day long for no apparent reason. So, right, I don't know what's going to make the market move. People buy GameStop stock, and it goes up because other people are buying it. I don't know any, right? So I'm not moved by, oh, it was all out there already. I could see someone saying, the only question, it seems to me, was, is it really about the key TAM action? I guess I see you're saying, because SKK is sophisticated or something, surely they didn't really believe this would move the market.
No, it's not even that. The record evidence shows the market wasn't moved.
That's different. The market not being moved and doing something that might have moved the market, right?
And the other aspect also, let's not forget, without losing sight of the fact that this is summary judgment and all I have to do is show a question of fact, is that there was nothing false.
No, but the question is whether it was material and non-public, not whether it was false.
Well, all three required for you can have a truthful, there could be a truthful statement.
Of course.
That's material and not disclosed.
Yes.
This information was already in the marketplace. It didn't move the marketplace. You don't want to hear the arguments about it not being material. I hear you. I believe that alone is enough to reverse summary judgment. But there is, on
Well,
the
if there was
record
no
itself,
other indication that it was retaliatory for the key TAM actions, I don't think so.
They fired him the next day without any investigation, and the record shows that there was no investigation.
Look,
Now, let me show you how.
You don't need an investigation, right? It depends what it is. An obvious disclosure of material non-public information or trading on it and then releasing it to the public. How much investigating do you think is necessary? If it were truly material non-public information.
That's exactly the point, Judge, and that, I submit on this record, tends to show that it must have been. Certainly there's a question of fact, or whether it was retaliatory animus, because had they looked at it carefully, had they engaged sophisticated outside counsel, they might have had this interesting dialogue that we're having now and explore and say, well, is this really material? Do we have personal exposure? Is this? They didn't do that. They rushed to judgment. They fired him right away, and then they asked him to sign a settlement agreement waiving his whistleblower claims.
So you say the settlement offer actually helps your position?
Absolutely. Absolutely. They very quickly asked
In
him
order
to
to
waive
keep
those
him
claims.
quiet, so to
Oh,
speak.
yeah. And, they thought themselves, I think they missed, well, what I think doesn't matter, but
Is the settlement offer admissible?
typically, it depends in this circumstance. When I go back and try the case, hopefully, God willing, and
Yeah.
you willing, whether and what...
Better
the
look into that.
Right, it will be fascinating, but I'm certainly going to cross-examine Mr. KROCHUK with respect what his intent was in seeking to get my client to sign this aspect of the settlement at the time, and I'm going to make certain arguments to the jury with respect to that. You believe me, that's my intention.
If there was one reason for termination that was not pretextual or retaliatory, you would lose, right?
I would want to
In other words,
flesh out from, yes, probably, I'd like to
There
flesh
could-
out from you what that might be, right?
There could be things that on their face look to be based on animus or retaliation, but there's, notwithstanding, there still could be perfectly appropriate reasons for termination. In other words, we could find that, well, we don't find things, but we could conclude that some of the acts appear to be pretextual, but notwithstanding, there was a legitimate basis for termination.
Of course. I mean, I've been sitting in the courtroom the last hour. If there was some sexual and inappropriate conduct that was otherwise documented in the record, and the record showed that that was one of the reasons for the firing, sure. I'd have a much more difficult argument, but that's not this case.
But your brother, at least as I understand it, says that your client admitted to certain facts that he now disputes about the timing of his short position, the unsealing of the actions, and the sending of the email. You say your client never admitted those facts.
He didn't admit those facts. What their argument is based solely on a pro se litigant's attempt to file a Rule 56 statement. The record evidence itself,
But was that signed under the pains and penalties of perjury?
the Rule 56 statement, the joint Rule 56
Don't
statement?
remember.
I don't think so.
Okay.
And it is contrary to, these were lawyers who were taking advantage of a pro se litigant. The actual record evidence below that, that's in this record, that cited in our brief, is to the contrary. He never admitted to committing a securities law violation without question. Judge Davis actually so found that.
Say that again? I didn't-
Judge Davis actually so found in his opinion, which I think is clear error, that not only did he admit it, that it's a fact. I say he was wrong with respect to both. The record evidence on the summary judgment, the affidavits and exhibits on the summary judgment motion, not what they were able to put in a Rule 56 statement that my client didn't really understand he was submitting. The evidence before this court shows, in fact, that he didn't admit to any securities law violations for doing anything wrong with respect to any rule or policy or either insider trading or ethical violation whatsoever with respect to his trading activity, all fully disclosed.
What's your closest case? Do you have a case, I mean, these are pretty unusual facts, but what's your closest pretext retaliation case?
It was one of the questions I was struggling with preparing for this. I don't really have one because these unique facts where such a strong statement is said with respect to the termination, where the the universe of the facts are really not disputed. The disclosure of the unsealing of the Ketam case, the immediately firing afterwards, as Judge Rubin observed, the conflicting stories reported contemporaneously by my client, and there's a May 4th email where he details the back and forth, which are clearly at odds with what Mr. KROCHUK says in his moving affidavit, that the court relied on, that the court really ignored that. And the termination agreement asking him to waive these claims, I don't have a case anywhere near that. It's a pretty, sometimes we get good facts and sometimes not so good. On this one, probably driven by the client not having counsel representing him at the time. We have, I think, pretty good facts from sitting on this side of the table today. Unless there are any further questions, I'm happy to.
No, thank you.
Thank you.
Mr. Brown.
Good morning, Your Honors, and may it please the Court. Chris Brown for Shepard, Kaplan, KROCHUK, or SKK. At the outset, I'd like to emphasize that this is not your typical retaliation case in which an employee blows the whistle on misconduct by his employer. Rather here, John Borzelieri accused unrelated third-party corporations of wrongdoing, and in so doing, caused no harm to SKK. Thus, what we're left with is an employer with no motive to retaliate and an employee fired for serious misconduct, grasping at straws to extract a
Why isn't fear of a defamation action a motive to retaliate?
That's not based on protected activity. His press release in which he publicized these allegations would be potentially defamatory, but that argument, Justice Rubin,
No, the
is
Ketam actions themselves might have been defamatory.
Well, pursuant to the litigation privilege, they wouldn't have been, and as Borzelieri has gone...
Well, I don't know anything about the legal advice you all got. Let me ask you this, because it's the question I asked your brother, and it seems to me the critical one. There's an email attached to this affidavit. It wasn't emphasized below, but it says that Tim KROCHUK told him the day he said separating, they're no longer concerned about insider trading after the Ketam documents, but some kind of defamation suit by the Ketam defendants against SKK, Borzelieri himself, and the fund investors was what their concern was. Why doesn't that raise a genuine issue of material fact? I'm not saying you would lose at trial, but why doesn't that raise a genuine issue of material fact, whether it was the filing of the Ketam actions that were the reason for the firing?
Well, because that argument is twice forfeit in this forum. One, it wasn't pursued below, as you know.
I'm sorry? Say that again?
All right. That argument is twice forfeit. It was not pursued in the court below, as this panel has noted. But in addition to that, that affidavit and the email it incorporates contradict sworn deposition testimony offered by Dr. Borzelieri, in which he says he was never given any reason for his termination.
No, I don't know if that's a contradiction. I don't know if that's a contradiction. He doesn't say in the email that he was told, and that's why you're fired. He says that KROCHUK said that SKK was concerned about this. That's not quite the same as being told, and because of that concern, I'm firing you. So I don't think they're inconsistent.
Well, I would suggest they are inconsistent. According to the story that Dr. Borzelieri tells, the context of that conversation was the explanation for his dismissal. And in fact,
separation, and he says no one mentioned termination, and he didn't understand it to mean termination. So, I mean, we can parse all of this, but I mean, if your argument is somehow other things he said contradict this, I mean, aren't we still in a genuine issue of material fact?
Not at all. The authority cited in my brief, Ing Brothers Construction, says that a litigant cannot withstand a summary judgment motion relying on testimony that contradicts other sworn testimony. Here, his affidavit, with this email incorporated in it, contradicts the deposition testimony that I just described. And to what the point you just made, here what that characterization of the email overlays Dr. Borzelleri's subjective understanding, advanced post hoc, of the context of this conversation about separation over what Mr. KROCHUK clearly meant, which is, we're separating from you, we're firing you, these are the reasons. You can't make something objectively inconsistent in what Mr. KROCHUK said based on how Dr. Borzilleri post hoc inconsistently understood it. But in addition to that, even if you leave that aside, the authorities on this issue of putatively inconsistent explanations for dismissal or shifting explanations for dismissal cited in my papers are fairly explicit that all inconsistencies do not automatically override legitimate reasons for termination. In the Claire versus Augusta Aerospace case, you had two completely different instances of employee misconduct relied on as explanations for the dismissal that were not evidence of pretext because both such explanations were reasonable and plausible. In addition, you have in the Battelle versus Pfizer case, also cited in my papers, different policies relied on to justify a dismissal, also not evidence of pretext.
But you agree that he couldn't, you agree that the statute prohibits him from having been terminated for filing the key TAM actions?
Yes.
So that wouldn't be a reasonable alternative basis for his firing?
Yes, that's right.
Okay.
The key TAM actions are not a lawful basis for his firing. However, what was a lawful basis for his firing was his violations of SKK's insider trading policy, which says an employee shall not trade in stocks when aware of material non-public information about them, period. It does not incorporate any of the glosses from statutes and cases that suffuse Dr. Borzelleri's papers in his presentation today. It does not limit SKK to enforcing its policy only in a situation where it has a private cause of action against an employee under the Private Securities Litigation Reform Act. The policy says what it says, and if that were not enough, the policy also provides that where a question exists as to whether or not an employee had access to material non-public information, it was for a managing member of the firm to decide whether to trade or not trade in an affected security.
But
no
the question is one of
provided
fact,
here.
whether that is the actual reason he was fired or not. And if that's the actual reason he was fired, then no liability, of course. But if the actual reason was even a mistaken fear of defamation actions from the key TAM action so that he was being fired for having filed the key TAM action, then there would be liability. I mean, right? That's the question. Is there a genuine issue of fact about whether this obviously valid policy, or frankly, any other reason, because the only reason you can't fire him is the key TAM action.
Exactly.
You can probably fire him, I mean, I don't know if he's at will or not, but you can pretty much fire him for anything, right? So there's no law against it anyway, right? So the question is only, is there a genuine issue of fact about that, I think.
Well, I don't believe that there's a genuine issue of fact because of that. There's not really any evidence of retaliatory animus in the record, and in fact, in Borzelleri's own papers, he says, and I quote, "There is and can be no question that Dr. Borzilleri was fired because he drafted and sent the press release." That's not protected activity, and that's his rendition of the issues. In addition to that, he says elsewhere in his papers that he was fired because SKK rushed to judgment about potential liability under the securities laws.
No, I think he says that the speed with which SKK acted suggests an incomplete investigation and a false reason. I mean, for you to stand there and say he doesn't say he was fired because of the key TAM actions is a misreading of the whole case. We wouldn't be here if he wasn't saying he was fired because of the key TAM actions.
Well, you know, as far as that goes, again, the authority that you can't contradict one sworn statement with another applies foursquare here. Borzilleri was asked in interrogatories, state all the reasons that you believe SKK acted unlawfully in dismissing you. This putative conversation with Mr. KROCHUK was not among them. In his deposition, he was asked similar questions. His sworn response was, "I never got an explanation about why I'm being fired." Now, for him to
Getting an explanation and there not being a reason are two different things. Lots of people are fired and they aren't told the real reason or any reason. right?
Well, the exact
Old
quote,
isn't part of the cause of action. The reason is the cause of action.
well, the exact quote from the deposition was, Mr. KROCHUK would never give a reason for the termination. So the
I don't
deposition
think that gets
testimony
you as
uses
far
your
as you
words,
seem
not
to
mine.
think. I don't know.
I'm sorry, I didn't hear that.
I don't think that gets you as far as you think. Not giving an explanation or his belief that it had never been actually explained to him, whatever, is fine. The question is there sufficient evidence to support a jury finding that the reason was retaliation? That's all. That's the whole, I think that's the only reason we're here, right?
Well, that's the crux of the analysis.
Okay.
But you can't contradict one sworn statement with another to get there, and even if you leave that aside, which I respectfully submit you shouldn't, the cases are quite clear that not every inconsistency allows you to get past summary judgment. The inconsistencies have to be severe and lack a common thread. Here, all of the explanations, whether putatively given by Mr. KROCHUK, according to Dr. Borzelleri's telling or otherwise, center on his policy violations and the press release. So, with that, another reason that this panel doesn't even reach this issue is Dr. Borzelleri's admissions pursuant to Superior Court Rule 9AB5, and I have to emphatically disagree with opposing counsel. This was not admitted attorneys taking advantage of a pro se litigant. Justice Meade, as you wrote, any litigant who fails to turn a procedural corner squarely assumes the risk that the consequences of his rule violation will be used against him. Here, SKK asserted as facts that the False Claims Act actions were not the reason he was fired, but rather he was fired because of his policy violations. And furthermore, the Supreme Judicial Court has said in the Maines versus Commonwealth case that pro se litigants are held to the same standards as practicing members of the bar. And if more were needed beyond that, and I would respectfully submit that it isn't, I think there's some question about how going it alone Dr. Borzelieri was really doing. There's references in his email to SKK, the same one that Justice Rubin references. My counsel and I are very familiar with all the whistleblower protection statutes, and later in a motion for reconsideration, he says, neither I nor several experienced litigation counsel who have reviewed the information for me in consultation agree with the summary judgment decision of the lower court. But that's not necessary. It's not one standard for pro se litigants and another standard for represented litigants. And to the extent that there's any discretion to relax application of Superior Court Rule 9AB5, that discretion rested with the lower court. The lower court chose, and this is apparent in footnotes 3 and 6 of its decision, to enforce the rule as stated. It is for this court to determine whether or not that discretion was abused. And as this panel well knows, abuse of discretion means no judge acting intelligently could honestly have taken the view expressed by him. We are nowhere close to the standard.
Can we just go back to the affidavit for a minute? Are you asking us to apply the sham affidavit rule?
Yes.
Are you familiar with the TAM case out of this court?
The TAM case.
TAM?
I don't think so.
Okay.
But I am familiar with the Ing Brothers construction case, which says that a litigant cannot contradict an affidavit with a deposition or vice versa, and that's what we have here. And if that weren't enough, there are also sworn statements in an interrogatory to the same effect. State all reasons why your termination was unlawful. None of this appeared there. And also in his deposition, as I mentioned before, he said Tim KROCHUK would never give
I'm looking at the interrogatory. Here's a sentence from it. Due to SKK's unprofessional and non-transparent handling of his termination, Dr. Borzelieri concluded that dissociating the firm from the key TAM actions was the true reason for termination.
Yes, but he didn't say...
So that's not inconsistent with anything in the email, right?
Well, I think it is. Well, one of the reasons that his termination was unlawful was that he believes his termination was unlawful was because here today he says, well, I got inconsistent reasons for my termination. Well, that's nowhere in his sworn affidavits. That's nowhere in his deposition
Non-transparent handling? I don't know.
I think that that's far too broad a level of abstraction.
Well, but you have to show a real contradiction if you're going to get any benefit from these contradictory sworn statements rule.
Well, then if you leave that aside, there's still the fact that this argument was not pursued in the court below on summary judgment. It's not in his papers. He filed a 30-page motion for reconsideration. It wasn't in those papers. And he was asked at oral argument on his motion for summary judgment 5 times by Justice Davis. Anything else, sir? Do you have any other reasons? Are you resting on anything else? And he said no. This putative contradiction in the reasons given for his firing appeared nowhere in his presentation in the court below. So I see that my time is almost up. With respect to whether or not there was a proper investigation, no legal authority required a proper investigation, and his papers are completely silent as to what a proper investigation would have entailed or what legal authority required one. But to the extent that there was some basis for that, he says that it would have uncovered inconsequential facts such as being anti-big pharma in the past or shorting stocks other than the pharmaceutical defendants in the Ketam cases. Those aren't the reasons he was fired. He was fired for his policy violations.
Your time is up.
Yes,
Yeah.
thank you.
Thank you both.
Whatever you want to do, I don't care.
We're going to go ahead and call the next case before we go on to Zoom. 21P 1140, Commonwealth versus Grabowski. Mr. Ciccarello. Okay, thanks.
Could you give me a paper towel?
May it please the court. As you know, my name is Daniel Ciccarello, and I represent Mr. Grabowski. Thank you for an opportunity to address you on this matter. As you know, it's Mr. Grabowski's contention that the trial judge erred in finding him guilty at the bench trial because the Commonwealth provided insufficient evidence to prove the elements of the crime. It is my client's further contention that if you look at Correction Officer Boyd's testimony, the timeline of the video, and the video itself, even in the best light for the Commonwealth, there's insufficient evidence.
Well, so I can only speak for myself. I've watched the video several times, and what I keep going back to, and the actual spit, I think, is at 3:35. But at 3:12, so just what, a few seconds before the spit, he calls the correction officer by his name, a very derogatory term.
Of course.
So I look at those together, right? You can't divorce the facts. You have to look at the entire video as it plays out. And I have to say, when you look at that name calling followed up very quickly by the spit, it seems pretty deliberate and intentional at this officer as compared to the first time that we see him spit around this time frame. So I'm struggling. I read your brief and I kept going back to, but in the light most favorable to the Commonwealth, and you got to help me with that because I look at them together and I'm having trouble with your argument.
Certainly. I certainly will. The issue is that whether or not Mr. Grabowski knew that that there was a correction officer in front of him when he spit. I would suggest to you, Gesundheit, I would suggest to you that there was his eyes were closed from 2:48
But his legs were being shackled at the time, right? Or attempted to strap his legs in.
Well, the question is whether or not he knew that, isn't it true that the question is whether or not he knew that there was a correction officer, not necessarily Boyd, but a correction officer in front of him at the...
There was the jingling of the chains and the movement in front of him.
Well, but if you take what Justice Blake's question is taking the totality of it, if I'm pronouncing that word correctly, then you look at hovering. There's 3 officers. They're hovering around him. He has his eyes closed.
But are they fully closed? I mean, I know he's suffering from the effects of the pepper spray, but sometimes you can close your eyes quite a bit and still see things in front of you, especially below you.
Well, the question is whether or not wouldn't that be speculation, Your Honor? Is there any testimony that he has his eyes open?
We're looking at this in light most favorable to the Commonwealth, not Mr. Grabowski. And on top of that, it's jury waived. And generally, I believe it's a bad idea for judges to say anything other than guilty or not guilty in a criminal jury waived trial. Here, the judge quite distinctly distinguishes the drooling or spitting relates to the effects of the pepper spray and then the intentional spitting. I mean, you can see him on the video. He's gathering the spit or phlegm in his mouth and then executes the expectorant onto the victim. That's certainly a plausible view of the evidence.
Well, I would suggest that we look at what the judge had said. What he said is, I think that it is clear that the defendant could hear and feel people around him. I would argue that that's correct up to a point, but not necessarily with Boyd in front of him, bending in front of him.
I take it your position is that the intent that has to be shown is not merely intentional spitting, but an intent to have the spit make contact with one of the officers.
Right, and you would have to say, to follow that through to his logical conclusion, you would have to say that Mr. Grabowski knew that there was a correction officer in front of him, and that he knew that there was somebody in front of him. I would suggest to you that looking at the video, that there is not clear evidence that
If he spit with reckless disregard of whether there was anyone in front of him, is that sufficient or insufficient evidence?
I would suggest to you that's insufficient evidence to show that, because I would say
I didn't ask you what the evidence showed. I'm asking you if spitting with reckless disregard for whether there's a police officer in front of you or whatever kind of officer these are in front of you. Reckless disregard.
Well,
you don't necessarily affirmatively know there's someone there, but you don't care deliberately, recklessly.
Well, the Commonwealth would have to show that it was not a reflective act.
But you keep avoiding my question. I take it your answer is, if it was an intentional spitting done in reckless disregard of whether there was a person in front of him, that is sufficient. Is that your position or no?
If there's sufficient evidence to show that.
If there was sufficient evidence to show those two things, not knowledge that he would hit someone or that there was someone in front of him, not an intent to hit someone in front of him, but reckless disregard of whether there was someone in front of him.
But that's not what the judge had said.
I'm not asking you, I'm saying, let's pretend that's what the evidence showed. Is that sufficient to convict of this crime, reckless disregard?
I would say that yes, that could be. Could be. But that was not what the judge had said. The judge had said.
I don't care what the judge said. The judge said guilty. My question now is there sufficient evidence to support the finding of guilt?
But, Your Honor, that's not the evidence that he had based his decision on. He's based his decision on that my client knew that there was a correction officer in front of him.
I thought he said there were people moving around in front of him.
Pardon me?
I thought you just read a quote where the judge said he knew there were people moving around in front of him.
Right, but it goes on to say that I find that the spit was directed out of his mouth and more than just a drool, that he was certainly, someone was down, that the judge had based his facts on based his decision on the fact that Mr. Grabowski knew that there was a correctional officer in front of him.
I'm going to read the entirety because it's 11 lines, because I think we're parsing it, and again, we need to look at the whole. The judge says, starting at 46, I've reviewed my notes, I've watched the video. There's two types of spits going on. One is almost a projectile, the first one, and the second one is a projectile spit. It looked like it was a spit with, force behind it versus just a coughing or drooling out. I think it's clear that the defendant can hear and feel people around him. Certainly someone down at his feet and ankle area in front of him. I find that the spit was direct out of his mouth and more than just a drool. His eyes were open and closed at a time, but certainly knew someone was down there. It was projectile spit.
And I'm saying to you, Your Honor, that there was not sufficient evidence for the judge to base that decision.
So you think these findings don't equate to guilt, or do you say that these findings are inconsistent with the videotape, or both?
Both.
What's inconsistent about these findings?
The inconsistency of the findings is that if you look at, if we look at the tape, there's no way, if you see that there is, C.O. Boyd is bending in front of Mr. Grabowski, his feet area. We don't see what he is doing there. When you go to his testimony, he does not say that he's actually touching Mr. Grabowski. Again, I argue that that the video is clear that shows that Mr. Grabowski could not see after 2:48. That there are people.
What if we disagree with you? How does that change your analysis?
Well, I think that there was insufficient. The point is that he didn't know that the person was there. If you say that you disagree and you see that it's there, I mean, I don't know what I can say to you except that I think that it's very clear that it shows that. I think it's also clear that he doesn't know where Mr. Boyd is because Mr. Boyd travels around. He goes, first he's on the left side of him, he goes to the right side of him, he goes to the front. I'm a little confused at the moment, but I think that the point is that he goes from left to right to center to down in front of the convict, and he bends over there. We can't see what he's doing. Now.
Well, but he does describe what it means to put someone in a restraint chair, which includes, among other things, 2 straps, one across each leg.
Right.
Comes down, and 1 strap on each wrist. That's at page 30 of his testimony. So, again, if you put all the, if you separate out the chunks, I understand, but we have to put them all together. And when we put them all together, why isn't it a reasonable inference from both the video and the officer's testimony about what you do in a chair restraint that, in fact, your client knew there was a CO at his feet?
Because the C.O. Boyd does not testify that he actually touched the man, and that is what.
You have to physically touch his leg. Isn't securing a strap around his ankle or lower leg enough?
He says on page 40, line 1, answer.
Page 40?
Yes, line 1, yes,
Okay.
ma'am. Yes, Your Honor. Down at his feet, so on my knees, my hands are down towards his feet.
Right.
Does not say that his hands are on his feet. And I would suggest to you that the Commonwealth has a burden to show that he's just not near it, that he's touching it, that there's a way that that Grabowski could have known that there was.
But if you keep reading, he says that he's touching his ankle.
He says not necessarily, unless it would be a complete requirement. The leg 8 irons, I believe, in that paragraph.
What about line 13 and 14?
And where is this leg iron normally? Just above his ankle. And it's touching his ankle? Yes. Does he say that he's touching his ankle? No. He says that the leg iron is.
Are you suggesting?
Are they touching his person?
I'm sorry. Are you suggesting the only way he can know that Boyer was there as if Boyer was actually touching him?
I would suggest to you, Your Honor, that there's the five senses that, aside from touching, tasting, obviously, but with the touching, seeing, hearing, or it's not smelling. Okay,
Why couldn't he hear him?
Feeling. So you would have that he couldn't. I would argue that that his eyes are closed during that period of time. That hearing is that the people are moving around and he can't focus. I don't believe that they would be able to focus on where this man is right in front of him, because there are other people moving, so there are other keys jangling. The second thing is that he wouldn't be able to feel him because there was no testimony that he was actually being touched.
Well, whether he was touching him specifically or strapping his leg down at the time of the spitting, right?
The question is whether or not he was touching him so he would know that he was there. That's the argument that the judge uses. I'm sorry?
Directly or indirectly, I don't think it matters, or at least I don't understand how it matters, that he may or may not have been actually touching him directly.
Well,
what matters is whether he spit at him, intentionally spit at him because he was there.
Well, you get to there's two parts to that, Your Honor. The first one is
general intent too.
There's two parts of it, I would say. The first one is whether or not he knew that somebody was there, a CO was there, not necessarily Boyd. The second thing, Your Honor, is whether it was reflective or not. I would argue that it was reflective because of for several reasons. The first one is that he was doused with pepper spray. It was quite clear that he had difficulty breathing and seeing.
I don't think it's clear at all what he could see.
Well, you have the phlegm that comes up, quite extensive phlegm that comes up.
I'm not saying he isn't suffering. I'm taking issue with your use of the word clear.
Oh, I'm sorry. I would argue that it would be clear.
Yeah, these are all very good plausible arguments for a fact finder, but why isn't it reasonable and possible for the judge to infer that it was indeed done on purpose?
Well, I go back
as he did.
I'm sorry.
I'm sorry.
I didn't mean to interrupt you, Your Honor. I go back to the argument about what the judge based his finding on. If he just said that, well, I just think that he just spit, that he had the intent to hit anybody, or it was as Judge Rubin was saying.
I think Justice Rubin said, he found him guilty. So that's our starting point.
Right,
can you tell me? You're saying it's impossible that he could have done this.
I'm not saying it's impossible, Your Honor.
Well, inferences only need to be possible.
I'm sorry. I didn't mean to interrupt you again.
No, you didn't interrupt me. You're fine.
My argument is that there was insufficient evidence to prove that there was intent to do it, and that...
I think we understand. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. My name is Rob Kidd. I represent the Bristol County District Attorney in the Commonwealth in this case. As Your Honors know, the question before the court is one of sufficiency of the evidence, and the general question is whether any rational trier of fact could have found this defendant guilty. In order for us to analyze that, we just need to look at the entire picture, and I think I would like the court to start from the beginning. This defendant was involved in an altercation with Boyer, the same person he spit on. He squared off against Boyer, very probably close in time to when
But he wasn't charged with any of that. He's charged with the spitting.
No.
And we have a videotape of it. So I feel like we've all been at cross purposes here a little. Why don't you tell me what the intent that had to be proven beyond a reasonable doubt was in order for him to be convicted? Because people seem to be using intent here in like 4 different ways.
Yes.
What is the actual law on this?
Actually, I think the defendant does a good job at his brief on page, I think it's page 11 of his brief, talking about the difference between knowingly and purposely. And assault and battery is a general intent crime, as the defendant puts out. That, as the defendant points out, that means that the standard is whether the defendant knew, the question is whether the defendant knew what he was doing. He intended to do the act.
All right, so let's start with that.
Yes.
If it was a volitional spit, then that piece is met.
Yes.
I guess it's not a secret, so I'll tell you. I looked at the video. I have very little doubt that a fact finder could have found that was an intentional spit. It's not stuff pouring out of his mouth. Maybe he's clearing his whatever, but he spits. So, okay. Is that the end of the case? Is that the only intent that the Commonwealth has to show?
No, for knowingly, he has to be, quote unquote, practically certain of the result that follows. He doesn't have to actually intend that he wants to strike a correctional officer. He has to spit practically knowing that that result will follow.
Wait, practically knowing is the test?
That's what the verbiage is, yes.
Practically knowing.
I have it here, Your Honor. Knowingly, he's aware of the result. He's aware that the result is practically certain to follow his conduct. That's what it is. He's aware that the result is practically certain to follow his conduct.
And the result that he has to be practically certain of, in this case, is that his spit will hit a police officer.
Yes, correction officer, yes.
Corrections officer. Now, your brother seemed to say that reckless disregard of whether or not it would hit the officer is enough. Do you agree with that?
It is enough, but my question, I haven't answered myself, is there is a separate crime for reckless.
Yes, I'm aware of that. It
battery.
seems to require injury, doesn't it?
Yes, yes.
And spit, I don't know if we have state law cases. I've seen federal cases saying that being hit by spit doesn't count as injury within this, within that meaning. I don't know if there's a Massachusetts case. Do you know if there is?
I don't, Your Honor. I don't.
Because to me, I look at the video, and it looks to me like what happens is he spits intentionally without any concern whatsoever for who it could hit. And maybe he thought this guy was down lower or up higher, standing there further back, whatever. Was he practically certain it would hit him?
Yes.
Geez, I don't know. Well, that's a hard one. I looked at the video like Justice Blake did, over and over. Like, well, what is it? And based on everything, including his reaction after he does it, which is he clearly doesn't seem aware initially that he's hit the guy with the spit. So, I mean, I don't know where beyond a reasonable doubt is, but this is a weird case. If all we had was oral testimony, he collected spit in his mouth and then spit me, okay, we'd say maybe a reasonable inference is but we can see him, and to me, it doesn't look like he is aware that he has spit on this guy even. That's not to say that he didn't, I also think he couldn't have cared less. You know what I mean? I think he was reckless. That's what it looks like to me. It looks like totally recklessly spitting. Of course, there's people around you, including in front of you. Maybe he's standing up. Maybe he's further away. Maybe he's not. Or maybe he thought it would hit him in the uniform because he didn't know he was bent down. I mean, spit hitting someone in their head like that is disgusting, and you would think it would elicit, as it did from the officers around him, a severe reaction, and he doesn't react at all. So I don't think he knew he hit someone. But I'm trying to figure out if reckless disregard, which is what I see, is enough.
My contention is that it was there were 3 officers in the room. He heard clinking around him. He knew where those officers were. He knew that when he spit, he had to have known that that officer was down at his feet adjusting those leg irons. His face was pointed down in the video, if you see it, and he spits directly on that person's head. The officer is at his feet, jingling adjusting the strap on his leg. It doesn't matter whether he's touching the defendant. The defendant had to have known that Boyd was there. Boyd is the same guy that he called the C word. It's the same guy he also said.
He had to have known. He had to have known. And if he didn't know, then I guess he was reckless.
Yes.
Right? See, that's where I keep coming to is if he didn't know, but he did it anyway, he didn't care, he was indifferent, there was an extremely high likelihood that there was someone he might hit with the spit, but he didn't care, and he did it anyway. I can certainly see that being a crime. Right? You can't, you know what I mean? I just shot the gun around, you know what I mean? And then, it hit my neighbor. Can you imagine? Right? Like, Well, of course it did.
Under the knowing standard, Your Honor, he doesn't have to intend to hit anybody. So we're close to the reckless, we're close to that language in reckless. Under the knowing standard, under the federal case that the defendant cited, he just has to intend that the act that he does, the spitting, and be practically certain that it's the result. I think that's similar to what Your Honor is saying.
Very close, I agree.
Very close. And one of the cases talks about the confusion between the general intent and specific intent crimes. It's in the notes, and it talks about how that over the years there's been, it's a very difficult concept to understand, and to the point where they're telling the judges, to avoid those terms when instructing a jury. So I'm just telling the court, it's by no means a clear distinction, and I understand Your Honor struggling with it.
Well, but the good news is, unlike the federal courts, we have said that spitting is an assault and battery. Out of this court in 2002, it looks like it's the first case that said it. Justice Grasso wrote for a united panel, and he said the Commonwealth needed to prove that without justification or excuse and without consent, the defendant intentionally committed a touching, however slight, that was offensive to the victim. Here, the touching was the intentional spat on the victim without her consent.
Yes.
I don't know why this case isn't on all fours with Commonwealth versus Cohen.
Well, but it's the question of intent. I would say that a fact finder could certainly find that he had the intent to spit. Did he have the intent to spit on the officer? That's the hard part, it seems to me.
I would like to point out, hope I didn't
Please.
interrupt you, some more evidence to consider, and I think we do need to go back to motive to do this. So we need to look at the whole facts, not just the video. We can look at the video over and over. Remember, I started with he squared off against this officer, right? So he doesn't like this officer.
Yeah, but that's, you're asking us to, having seen the video, we can't draw an inference that the video doesn't support. Do you see what I mean? Like, I get what you're saying, but once you have if in the video, notwithstanding everyone's testimony, he didn't spit at him, he handed him some flowers, even though he hates him, we wouldn't say, well, a jury could have found he spit. We'd have to say, no, the video shows him handing flowers.
It goes to prove that out of the three officers that he could have struck, he happened to strike the one he almost fought with.
He hates all of them, but okay, he hates this guy. I grant you that. But I have a hard time getting to he knew the spit would hit him. I don't have a hard time getting to he couldn't have cared one way or another.
All right, then I want to go back to Judge Grasso's case, and I know it's not in your brief. The offensive touching may be direct, as in striking another, or it may be indirect, as by setting in motion some force or instrumentality with the intent to cause a battery.
Yes.
But he has to intend the touching. Now, you say there, and you're right, there's this recklessness theory of assault and battery.
Yes.
Do you think that the spit counts as the kind of, first of all, can we affirm this if we find it meets the recklessness?
Yes.
Okay. Do you think that spitting is the kind of injury that counts for reckless assault and battery?
Oh, yes. Spitting is, as Justice Blake just pointed out, spitting is an assault and battery, and then not in this particular case.
Well, spitting on someone is.
Yes. So in this particular case, the question is whether or not, but the question is what his level of intent was, as Your Honor pointed out. So it's not spitting per se, it's whether you intend to hit somebody with your spit.
Yeah.
And the facts absolutely support reckless, I suggest a reckless disregard for somebody being there and an intent to strike someone. And the question is whether any rational trier of fact could find the evidence.
No,
I would also like to point out, before I forget, and Justice Blake brought up a case, I discovered a case, or my colleagues discovered a case, an unpublished decision I will just bring to Your Honor's attention. It's Commonwealth versus Calixte, C-A-L-I-X-T-E. And it's what's the number? It's, here. I'm sorry, it's number 17-P317. It's a 2017 unpublished decision. Anyway, in Calixte, it was just the same facts as this. It was a defendant who was pepper sprayed by the police. And in that case, the defendant also argued that the conduct was not intentional. It's a little vague as to exactly how he says it was not intentional, but the court said, we disagree. After the defendant was sprayed with pepper spray, he deliberately gathered phlegm in his mouth, and he turned towards Hendrickson, and he spit directly at her. In this case, if you remember in my brief, it will tell you that the officer testified that he heard the defendant make a KKK sound as if he was gathering phlegm. That does not come out on the video, but my suggestion is that the officers were standing right near the defendant, and it's a low guttural sound, and the officer could have heard that. So I would suggest to you that is very suggestive of a person gathering material in his mouth in order to spit. So I'd like to point that fact out to the court. And yeah, so I'll stop talking and rest on my brief if there are any other questions. Okay. Always less said, less mending, as my mother said.
Thank you both. We'll take it under advisement. That's going to come to an end for the in-person session today. I'd like to thank our court officer, our court staff, my colleagues, our law clerks, and the excellent timekeeper. With that, we'll stand in recess.
What is that in recess?
Good job. Nice to meet you. Nice to meet you.
Right down to the nanosecond.